Evening. Thank you so much for joining us this evening. And we are going to start a very special panel with an amazing panel of guests, which I will get to shortly. This is going to be an hour-long panel to address the legal landscape in 2022 for queer and trans mothers. We're looking at milestones that have been brought up to this point, some goals that we hope to achieve, some things that have been achieved, and to also talk about some things that as community members we should be thinking about. We are doing this panel workshop this evening in partnership with NCLR. And so we want to thank NCLR as well for co-hosting this event with us. I am Mimi Demissew, the Executive Director of Our Family Coalition. Our Family Coalition is an organization that's been around for 25 years in support and dedication to support LGBTQ headed households and children. Before we begin, we like to do a land and labor acknowledgement. We understand that our theory of change is rooted heavily in intersectionality. So, and we also want to be cognizant of where we are and how we've gotten to this place. So let me start with the acknowledgement of land. Most of our work takes place in San Francisco, which is unceded Ramaytush Ohlone land, and the East Bay, which is unceded Chochenyo Ohlone land. The theft and occupation of this land is part of a centuries-long genocide. We acknowledge and express gratitude for the Ohlone people who have been living on and working this land for centuries. We also want to do an acknowledgement of labor. We further acknowledge that much of what has made this nation strong, namely its culture, economic growth, and development, has been made possible by the labor of the first 12 generations of Americans of African descent, who between 1607 and 1865 suffered the horror of the transatlantic trafficking of their people and chattel slavery. Following emancipation, Jim Crow and de facto segregation continue to constrain and erase the labor generations more. We are indebted to their work and their sacrifice and acknowledge the broad multi-generation impact of that violence still felt and witnessed today. Today's panel topic is in context with March being Women's History Month. We came up with it to not only think about the history of what we've done, but it's an opportunity to do more, to look at the present, the future, and to look at the changing legal and cultural understanding of women and mothers, connection to current events, and what's important right now. The panelists that we have with us this evening is Cathy Sakimura, who is the Deputy Director of Family and Law at the National Center for Lesbian Rights. Naomi Goldberg, who is the Deputy Director and LGBTQ Program Director at Movement Advancement Project. Dana Rudolph, who is a publisher of the GLAAD Media, and Lisa Runion, who is who was a litigant at a major case that provided legal rights to non-biological mothers. So we're very honored and excited to have them here with us this evening. So without further ado, let's begin. I'm going to first ask Dana to open us up and to talk to us about, what the legal landscape is today for queer and trans mothers, and where do you find your attention is drawn?
Well, thank you, and thanks to our family for having us. I should just note, I'm not actually with GLAAD. I run the blog Mombian for LGBTQ parents, which did win a GLAAD Media Award a few years ago. But yes, I'm going to give the whirlwind tour of LGBTQ parental rights in the 20th and 21st centuries. And then Cathy, I'm sure, can fill in a lot of the details about where we are today and what's going on. So we first hear about LGBTQ parents actually around the time of World War II, and mostly in the context of cases that deny them custody of their children when heterosexual or when different sex couples divorced. And then starting in the 1970s, just post Stonewall, we first start to hear of some state courts upholding rights for LGBT parents, although some still required that they didn't live with their partner and put other restrictions on them. But it's sort of a gradual opening up. And we then I guess mostly in the 70s, maybe late 60s, we also start to see LGBTQ parents having kids together as queer couples, or as single gay people. In fact, Bill Jones was a gay man. In 1968, became the first single father to adopt in California, and I think he was one of the first nationally as well. But he sort of downplayed the fact that he was gay in order to get that adoption. Then in the 1970s as well, we start to see mostly female couples and single women beginning to start their families together through pregnancy. And I say female couples, that's how they typically presented themselves. And that's what we hear of mostly, although I know there were trans couples and people of other genders there as well. Unfortunately, the records, I think, are not as clear about that. But we start to see these queer couples deliberately wanting to have kids together, and the first sperm bank opening specifically to serve them in 1982. That was the Sperm Bank of California. We also see in 1985, I think it was, the first second parent adoption or confirmatory adoption, where a non-biological parent gets legal rights over the biological parent's child so that they can raise the child together, both legally. And that's something that I'm sure Cathy will speak more about in the context of what's going on today. But that started back in 1985 and was really a key advance there. Whoops, and somehow my screen just went out, so I'm losing my notes. But let's see, give me just a moment here.
No worries, take your time. That's a lot of rich information.
Here we go, yeah. So let's see, we're rolling through the 70s and starting to have kids, and then by 1985, realizing that couples needed to get legal rights together over the kids, which started the idea of second parent adoptions. The marriage equality movement obviously started to gain momentum in the late 20th century there as well. We have to be careful talking about marriage rights and parental rights, because while they're connected in many ways, they're also somewhat different. But I think one interesting point for this discussion is that the early marriage equality, the early arguments against marriage equality were very much focused on keeping LGBTQ people away from kids. And that was an argument used during the Proposition 8 battle to ban marriage equality in California, for example. But by the time we get to the Supreme Court decisions in 2013 and 2015 that helped legalize marriage equality, ultimately nationwide, that argument has really been reclaimed by the LGBTQ advocates, and the best interest of children used as a reason to give same-sex couples marriage rights. However, even with marriage equality, and with marriage equality giving same-sex couples in many states the ability to adopt where they didn't have it before, it wasn't until 2017 and another Supreme Court case that really confirmed that non-biological parents have a right to be on the birth certificate of their same-sex spouse, who is the biological parent. So even after marriage equality, there were other rights that still needed to be worked out separately for parents. And then we fast forward to today, where we're seeing a number of states like California, like most of the New England states, really starting to implement broad, comprehensive, and inclusive parentage acts that do things like make all the parentage statutes gender neutral to really include trans and non-binary parents and parents of any gender parenting with parents of any other gender, recognizing de facto parents, people who have the status of a parent or acting as a parent, even though they may not legally be one, recognizing unmarried parents a lot more. And I'm kind of rolling this all into a ball that the rights differ a little bit state to state. But there are a handful that are really doing some great things in that regard. And I know Cathy will talk more about that. But on the other hand, we're also seeing states, more conservative states, start to implement what we call religious exemption laws, which allow adoption and foster care agencies to discriminate against LGBTQ parents. And we see what's going on in Texas and in Florida these days with trying to put restrictions on LGBTQ content in schools, which obviously affects us as parents quite a bit. So there's this growing division, I think, between the states that are really crafting thoughtful laws around new families today, and then the ones that are really trying to resist that. And with that, I think I will kick it over to Cathy, I think, who's next to pick up on that and kind of take us into where we are now.
Thanks so much, Dana, for that history. I'm Cathy Sakimura, the Deputy Director and Family Law Director at the National Center for Lesbian Rights. And we do work on behalf of all LGBTQ people and their families in every area of the law that impacts them. And NCLR has always had a specific focus on family law in particular, because that was the original focus of our work, was on parents who were being denied recognition or denied custody of their children. So it's always been a really big part of our work. I want to fill in a bit about kind of the issues that arise for families now. There's a lot of different areas where that can come up for families, and many families, both LGBTQ and not, do experience some family law issue or case in their lifetime. It is probably one of the most common ways that people intersect with the legal system, but there's lots of different ways that could happen. So first, I want to talk a little bit about what were in some ways the first cases, which were people who had genetic children, not through assisted reproduction, who simply have faced losing custody of their children or even having their parental rights terminated because of their sexual orientation or gender identity. And some of the history that Dana covered includes those really early cases that were especially involving lesbian and bisexual and gay parents, particularly lesbian mothers, often losing custody of their children early on simply because they had come out about their sexual orientation. And then we have developed a lot of law about how that isn't a reason to lose custody of your child, although it is something that does still happen to people in some states and in some circumstances where it can at least be an issue or a factor, although most states have made it have some law saying that that's not appropriate to use someone's sexual orientation to say you can't be a fit parent just because of that reason. Unfortunately, for transgender parents, the law has not advanced that far, even though the principles should be the same and the law should apply that same way to people who are transgender or who are transitioning, and they shouldn't be losing custody of their children just because of their gender under the same principles. In the reality, that is what is still happening for people even in every state. So we see a lot of situations where, especially as a parent is going through transition during a custody battle, having that used against them to deny custody or to have supervised visitation, or even having horrible orders like that they have to present themselves as the gender they were assigned at birth during their visitation time, things that are untenable and harmful to them and their children. And so that's still a reality that a lot of transgender parents face. We also know that LGBT parents and especially LGBT parents of color interact with the child welfare system and are harmed by it at vastly disproportionate rates, especially Black LGBT parents. And that means that not only can you potentially face a custody challenge in a dispute between you and the other parent, but even when you're still together, that the state could come and separate your family for discriminatory reasons. And we have seen cases where transgender parents have even had their rights terminated because of their gender and because they are transitioning, especially for parents of color.
Cathy, if I can stop you right there. Under what basis are people coming in and taking away these children? What's the legal precedence for this?
Well, the child welfare system has very broad definitions in which it can come in and investigate families and to separate them that usually fall under neglect. Although sometimes there are courts that say by presenting yourself as a gender you were not assigned at birth, that you are abusing your children by harming them and confusing them. All of the horrible kind of stereotypes and terrible things that people hear can be used in the context of separating families. Similarly, we see cases where even for parents who are not LGBT, when they have transgender children or gender nonconforming children who they are supportive of or affirming of, can be separated from their children as seen as forcing their children to be transgender and that that's harming them. And that's a reason for the state to step in. So this is connected to the broader way that child welfare system harms many families, LGBTQ and not, because of the very, very broad definitions of what neglect can be, and the reasons why families can be separated can really be based on either unconscious or conscious bias, just families not looking the way that that is expected in the mainstream, and just families that aren't the way that a court or a caseworker wants them to look like. And that is something that impacts lots and lots of families, and it has a particular impact on LGBT families.
Thank you for that. Sorry.
Absolutely, absolutely. So it is, I think, an area that's really important for our communities to be talking about, which is not just for LGBT adoptive parents, but for LGBT parents who have children, even if they're legally recognized, can still be separated by the state for discriminatory reasons. I want to talk also a little bit about the ways that you might establish you're a parent if you are in one of these situations and it's not clear that you are a parent under the law because you're not genetically related to your child or you haven't adopted your child, for example. So I've covered so far what happens even if you're recognized as a parent, but you can still be discriminated against. But also, we have a lot of questions that come up for people about whether you are even a parent who can come in and say, I would like to have custody of my child because I am their parent, and whether or not you can even ask that question to a court. And Dana alluded to a lot of the amazing development of the law over the last few decades that has allowed that recognition through the ability to access adoption for couples who are able to do that, but also the recognition of lots of different ways of forming families, recognizing that same-sex couples can be married, that transgender people can be married, and recognizing parentage based on marriage, as well as de facto parentage or other kinds of laws that look at whether or not you function as a parent in a child's life, and that being a reason, as well as laws that are more broadly looking at assisted reproduction and ensuring that everyone who uses assisted reproduction could be recognized as a parent, whether or not you're genetically related to your child and whether or not you give birth to your child. There's still a huge patchwork of laws across the US, and every state addresses these issues in different ways. So unfortunately, there's still a really long way to go before every state really recognizes all the ways that LGBTQ people have children and form families. But we've made a lot of progress, and there are a lot of states that are seriously looking at ways to have expansive and comprehensive laws that really try to capture all the ways that families are formed. And so I think it's been really an amazing process over the last few decades, but there's still a long way to go. And finally, I want to give a little bit of details about what to do if you're thinking about having children, and the kinds of considerations you want to have about how would you make sure that your parental rights are protected when you do have children. So of course, as Dana mentioned, that adoption now, every state allows LGBT people to adopt. Some states do still restrict adoption by two parents to married couples, but many states allow couples who are unmarried to adopt, and every state allows a single parent to adopt. Adoption can be obviously through independent adoption or through foster care adoption, but also our families can, of course, use adoption to establish that we're parents and make sure our parental rights are protected and respected, even if we're conceiving children through assisted reproduction. But it is important to look at the laws of your state and find out. And I will put a link later in the chat to NCLR's helpline if you want to get more information about the laws in your state to see whether your state recognizes people who conceive children through assisted reproduction as parents and what the requirements are, because there's a huge variation. So some states, for example, will only recognize married couples. Some states will only recognize parents who used a doctor or a clinic to conceive and won't recognize people who did at-home insemination. And some states have much broader laws. Some states clearly recognize what a lot of people call reciprocal IVF, which I know we will talk more about as well, which is when you have two parents who are intending to be parents where one of them has a uterus and is going to carry the pregnancy and give birth, and the other person has eggs or ova, and the child will be conceived through IVF using the eggs of the second person, but they're both intending to be parents. And that is an issue that can come up about, well, if you give birth but you're not a genetic parent, are you a parent? And if you're a genetic parent whose ova were used but you don't give birth, can you be recognized as a parent? And that's another issue that comes up in states that don't have really clear laws. Another great possibility in a number of states now, there's 10 states now that allow this, is that many states are starting to allow people to sign voluntary acknowledgements of parentage at the hospital when their child is born, which is a great, easy, free way to establish you're a parent without having to go through the cost and difficulty of doing an adoption or getting a court order. It has essentially the strength of a court order. It's supposed to be the same as getting an adoption, but it is still something that's new for courts and for states. And where it's available, though, it can help so many more families get protected and recognized than we're able to access protections through adoption. And the last one I wanted to point out in terms of like the newer areas of law is getting streamlined or confirmatory adoptions. So a few states have this and more states are considering it, which is people who are parents because they're married or they used assisted reproduction should be able to get an adoption to recognize they're a parent, even though they are parents already, in a way that's free and easy and doesn't go through a lot of the things that adoption would normally require, because adoption assumes that you don't live with and aren't raising your child already. And that can be a great way for people to more easily access an adoption judgment. So there's lots of new things happening in states, and legislators are considering these in many states. And I think that's a great way for parents and people in the community to be involved in this movement, which is to find out what's happening in your state. Are there bills that are being considered? Perhaps your representative might be interested in authoring or sponsoring a bill, and to become involved in that process and speaking out about your family and your community. And it's a way that we can all be involved in advancing the rights of LGBTQ families. And with that, I want to turn it over to Lisa, who I'm so glad is joining us to talk to us as a parent who went through this litigation that some parents unfortunately have to go through, and through the process helped many other families as well.
Well, thank you. And I want to thank NCLR because they were with me pretty much all the way through my case. My case was in 2005, Christine H. v. Lisa R. It was a case where, and I'll go into a little background of it first, so you can understand what was going on. We first were pregnant with twin boys, and my partner worked at a facility that did not offer children dependent health care. So we were carrying the twins, and it turned out that they had a really big issue, and they were going to be born without health insurance, because our plan was I would adopt them as a second parent after they were born, and they'd be on my insurance and everything would be great. So we learned the hard way. They unfortunately passed away at birth, so we didn't have to figure out the finances of paying their medical bills. So when we got pregnant with our daughter, we went ahead and did some thinking ahead just to make sure that she would have insurance, everything would be great. So we went and had one of those pre-birth declarations of parentage established, where we went and formed a court order, and it put me on the birth certificate, and everything was great. And our daughter was born. 3 years later, the relationship broke up, and my partner tried to rescind that pre-birth declaration of parentage based on subject matter jurisdiction of the court, saying the court had no right making this order, et cetera, et cetera. So we ended up at the California Supreme Court, and luckily I won the case. And after the case, they went ahead and changed all the birth certificates in California to parent and parent. They no longer have father and mother on the birth certificate. So it was pretty much a wide open. It opened a lot of doors for people, and it was a scary time, because at that point, if that pre-birth declaration of parentage would have fallen, all the surrogacy agreements in California would have fell with them, because that's how they signed off on the surrogacy. Because we went to a surrogacy attorney and got our paperwork all. We thought we were good. Unfortunately, it took 3 years to gain custody of my daughter. I had visitation, rare visitation for those 3 years. But at the end of it all, I have my daughter, and she's 21, and a 21-year-old wild girl right now. So I'm very thankful for everybody that helped me. I was lost at the time, did not know what to do. Here I was saying, I need help. And I called up to NCLR one day. They said, come on in. And I sat down and talked to them, and then the ball started rolling. They got on board. All the agencies and they were out there were writing amicus briefs for our side. And a lot of amicus briefs were written on the side of the right-wing conservatives, saying, we don't want this to happen. They shouldn't have children, et cetera, et cetera. We know the routine of that. But it was a very scary time. And what's interesting now is I have a 28-year-old stepdaughter who is about to marry her partner in July. And they talk about having children, and they don't have to talk about things like how they're going to have medical insurance. What are they going to do for second parent adoption? What are they going to do for the things I had to worry about, or we worried about 20 years ago, which is pretty amazing to see. They worry about the things like who's going to pay for school, who's going to, how are we going to get the baby daycare, et cetera, et cetera. They get to worry about things that a straight family gets to worry about, not things like, will somebody take the baby away? Will I have parental rights? So I've seen the growth in California in the last 20 years because of this. But I'm in an isolated situation. I had my disaster situation, and now I'm seeing them be able to do this just as a normal couple, which is wonderful. They don't have to worry about what I had to worry about.
Thank you for sharing that. I think a lot of us who don't know that history, who don't know the fear of having a child and the fear of what if this child is taken away from me, or even being arrested. There was just so many things that people had to be worried about, losing your job,
Yes.
I mean, it was an incredible struggle, and I mean, that pushed parents underground as well in trying to have, in going through that family formation process. So thank you for sharing that lived history.
You're welcome.
That's profound. Sorry. Naomi, if you're.
Good evening, everyone. And Lisa, I want to thank you for sharing your story and for the amazing work that NCLR has done. I'm reflecting on my own journey to being a mom, and that those moments, right before my son was born, of like, what happens if something happens to me, before my wife has a chance to adopt him, and how scary that was as you're about to be so excited because you're having a baby. So as everyone said, I am so excited to be here and to join Cathy and Dana, who just do incredible work, as well as Lisa and your great story. I'm going to pivot us away a little bit from parental recognition and family law, but I want to keep us focused on the areas of law that do impact our families and places that our families have to navigate, and that where we live, where we as queer and trans women and mothers, where we live really matters. So by way of quick introduction, as Mimi said, I'm Naomi Goldberg. I am Deputy Director at the Movement Advancement Project, where we do messaging research, policy work, and movement assessment and capacity building work. So much of the work we do is really behind the scenes. But one thing that we do is track state laws and policies across the 40 states, DC, and the 5 territories. And in doing so, we think a lot about the laws that impact LGBTQ people because of their sexual orientation or because of their gender identity. And I think, I was so excited to get invited today to this panel, in part because I am a lesbian cisgender mom. I have an 8.5-year-old who I'm raising with my wife, and I live in Ann Arbor. But I think it's important to note with our Family Coalition work that I grew up in the Central Valley of California, and I'm always in awe of what exists just over the hill in the Bay Area. And as a kid, I went to see Rent when I was about 14 in San Francisco, and just thought this is like Mecca. So I'm very jealous of all of you who live in the Bay Area, but also am thrilled to live in sort of the haven of Ann Arbor. So I'm going to focus my remarks on a few different spaces that we as queer and trans moms may engage regularly, and the protections that exist or don't. And I'm going to share a couple of slides because I like maps, and I think having a visual can be really useful. So let me do that real quick. Okay, can someone just put a thumbs up as to whether you can see my slide? Okay, Cathy, I see Cathy's thumbs up. Awesome. So that's me and my wife and my kid, but we'll go to the next slide. So, as Cathy mentioned, some of our families form through foster care or adoption, but also, some of our families engage with the child welfare system for other reasons, whether it's removal proceedings, as Cathy mentioned, or folks are trying to access family preservation services. So potentially there's been an investigation, and you have to go through classes or things. And unfortunately, you can see here on this map, the states that have the caution signs. There are 11 states in the US that allow state licensed child welfare agencies to refuse to place children with LGBTQ families or to serve LGBTQ families and same-sex couples, as well as families that may not meet their sort of religious faith requirements. For example, here in Michigan, where I live, just recently, the Attorney General signed a statement or a settlement with a faith-based child welfare agency that gets state dollars to care for children who are in state care, saying that they don't have to work with LGBTQ families if they don't want to. And so I feel like that's a really concerning thing when we think about, as Cathy mentioned, the fact that queer and trans parents do engage with a child welfare agency, whether because they want to become a foster parent or they're seeking to foster to adopt, or because for unfortunate reasons, they're engaging with the system, whether discriminatory or otherwise. And so what happens when families can't access services that are near where they live? All right, I'm getting a note that I should make my slides a little bit bigger. Let me zoom in potentially, see if that helps. All right, is that any better? Now you can't see them at all.
What you had just at that very beginning was great because we could just see the slide and not the rest of your screen.
Okay.
It was bigger.
Great. Sorry about this, everyone. Problem is then I can't see my notes. Let's just see what we can do if I slide this over. Let's try that for now. So as I mentioned, there are these states where we have child welfare agencies are permitted to adopt or to discriminate against families. On the flip side, we also know that there are states that have either explicit state laws or agency regulations or policies that prohibit the kind of discrimination that I'm talking about, both against LGBT kids who are in the child welfare system, but also against families. And so you can see the states in the dark green. Those are states where there are protections in the foster care system for sexual orientation and gender identity, and that kind of like light pea green is for sexual orientation only. So the good news is that we are seeing changes across the country. I do want to note that if Congress were to pass the Equality Act, this would mean that no federally funded agency, including state contracted child welfare agencies, which inherently receive federal dollars, they would not be permitted to discriminate against LGBTQ children or families. And so I think it's really important to note that that federal law would really shift the landscape, which is different, I think, that many of the instances that Cathy and Dana were talking about earlier, where federal law has sort of not a lot of role in state level family decisions about who is a parent and who isn't. But there are places where our families engage where federal law can really do a lot. We'll talk a little bit more about that in a couple minutes. Especially since we've all been navigating the pandemic, I wanted to mention briefly that we know that LGBTQ parents have been really having a challenging time during the pandemic. So when we look at, for example, balancing work and education, this is data from August and September 2021. And you can see here that 58% of LGBTQ households surveyed reported that their kids were falling behind, compared to 35% of non-LGBTQ households with children. And I think that this bottom stat is really what is kind of hits home for me, especially as a working parent, which is the idea that LGBTQ households were twice as likely to say that they had serious problems meeting work and family responsibilities compared to their non-LGBTQ peers with kids. And I think part of why that is that many of us are navigating sort of a system where there's lack of access to paid family leave, to sick leave, and that there are sometimes narrow definitions of spouse and partner and child that can make it harder to take time off when a family member needs you to. That said, I think it's important to note that under federal law, if you were to take Federal Family Medical Leave Act, the definition of child is intentionally defined to be quite broad, relying on something called de facto parenting. And so if you're parenting a kid, regardless of the legal recognition, you should be able to take Federal Family Medical Leave Act time. And I think that's just an important note. I think there's also something important to flag in terms of employment. I feel like many queer families navigated employers getting a look into our lives during the pandemic, with children running around and spouses coming in to grab children and all of these different things. And the good news is that for queer and trans families, we do have a really sort of a patchwork, but an exciting patchwork that's emerging around employment law and protections. So in 2015, the US Supreme Court ruled, not 2015, I'm sorry, 2 years ago, pandemic time has gotten to me. 2 years ago, the US Supreme Court ruled in a case called Bostock that you cannot be fired from your job for being queer or trans under existing federal employment law that protects you from discrimination based on sex. So federally, the great news is we have protections. I do want to note that that law applies to employers that have more than 15 employees. And so if you work for a smaller employer, you may be left kind of navigating the patchwork of state laws. And so if we look at that patchwork, we see that it's definitely a lot less clear. So the dark green states are states that have explicit laws prohibiting discrimination in employment based on sexual orientation and gender identity. There's one pea green state on there, Wisconsin, that their law only explicitly names sexual orientation. We have these striped states that are sort of, I think, very interesting, which these are states that either before the US Supreme Court decision, or most of them immediately after, have interpreted their own state employment laws that have sex protections to also cover LGBTQ people because of the Supreme Court ruling in Bostock. And so those are the states that are striped. But then you still see we have 16 states and 3 territories in this kind of light beigeish color that lack explicit or interpretive protections for LGBTQ workers. Again, most people in these states can file with the EEOC through federal law if you are experiencing employment discrimination, but it is important to know this is another place where the Equality Act would help clean things up, make it explicit, and also, help signal to states the way that they need to be thinking about their own state laws. So shifting from work, I want to move into the space of like where we as parents often spend our time, which is at the doctor's office with children, thinking about vaccinations and checkups and sick visits. And I know that many of us also rely on childcare to help with our kids when we're at work or we're at school. And I feel like this is another area of law that is quite complicated for LGBTQ parents, but it's noteworthy to sort of parse out where we're at. So under federal law, it's currently illegal to discriminate in healthcare contexts because of sex. And both the Department of Health and Human Services and the Biden administration have said that that can be interpreted to include sexual orientation and gender identity. We know, however, that healthcare providers are definitely turning away LGBTQ people. They're saying that they'd like to not serve trans folks in particular, and they may not want to serve even our kids. There was a case here in Michigan where a pediatrician, after learning that a couple was going to have a child, it was a lesbian couple, that they didn't want to see that family anymore. And we know that there are also states that are passing healthcare laws that explicitly allow them to say, I don't want to provide service to someone. And we haven't seen a ton of enforcement at the federal level. So I feel like this healthcare space is one that's complicated. And that ultimately that complicatedness means that our families often worry about finding a pediatrician who might see our children, or finding a physician that will do an insemination if that's what we're looking for as a way to create a family. And of course, I think we should note that many of us are watching as states are passing laws that are trying to ban best practice medical care for transgender youth, which obviously I think also has a chilling effect on the ability of adults to access best practice medical care. So what is sometimes surprising, though, I think for people to realize, is that it's not illegal under federal law to turn away a woman, whether she's queer or trans or not, from a public-facing business like a restaurant or a store or a taxi. That federal public accommodations laws do not prohibit discrimination based on sex or sexual orientation or gender identity. The good news is that many states have public accommodation laws that prohibit discrimination based on sex, and then far fewer still have protections for LGBTQ people explicitly. So if we look here at this chart, the dark green again states that prohibit discrimination based on sexual orientation and gender identity in places of public accommodation. So that's kind of every place you go when you're not at work or not at school that are public-facing businesses. So these are the states that have great protections. Again, we have Wisconsin in that light green that's just for sexual orientation. We have fewer states that have interpreted their own public accommodation statutes that prohibit discrimination based on sex to also apply for LGBTQ people. But then we still have 21 states where there's really no protections for LGBTQ people in these public businesses. So I start to think about places like daycares and preschools and restaurants and play spaces and retail stores where many of us go with our kids regularly. I want to close the conversation for now talking about schools. It's a place that we as parents, well, I at least used to spend time there before the pandemic. We still can't visit my child's school, but where we spend time and where our kids spend time. And I think it's a place where it is nice to feel welcome as a queer family, but there's often, nervousness about that. And I know I have been watching what is happening in Florida, thinking about my own child and my own child's experience in school. So on the one hand, we know that LGBTQ youth themselves experience discrimination at school. They experience bullying and harassment. We know that trans kids are often not allowed to use correct pronouns or not allowed to use bathrooms or plan sports teams that match their gender. And there have also been cases where children of queer and trans families have been turned away, primarily by religious schools. Thankfully, though, there are Oh, it's picked. My map didn't update. Well, I don't have a map for this one, but I am excited to tell you that there are 13 states in the District of Columbia that have laws that actually protect kids from bullying based on an association with someone who has a protected characteristic. So this means that kids who have a parent who is a person of color, or a parent who is queer, or maybe a parent who is a queer person of color, can't be bullied because of their association with that person. And I think these are really great innovations to help make sure that kids with queer families aren't being bullied or discriminated against. Speaking of Florida, I wanted to show this map here, which is focused on school censorship bills, particularly the flavor that are focused primarily on LGBTQ issues, not the ones that are focused on discussions of race or accurate US history. But we know that there are several states across the country where discussions of LGBTQ people and topics can't be discussed. So you can see in the darkest color, these are places where states have laws that don't allow people to talk about LGBTQ issues. We also have states that require parents to be able to opt out of these conversations. And while some of these laws predated what we're seeing this year, ultimately, all of them tie the hands of educators to respond in age-appropriate ways when conversations about things like family diversity come up. I know I'm nervous that if my son talked about his family and what we did over the weekend, and maybe a classmate said like, well, that's weird, right? He's in 3rd grade. That a teacher in Florida may not be able to respond with affirming language and then offer some information about the diversity of families, or to be able to bring in a book to talk about how families look lots of different ways, but love is what matters. So I think these laws definitely implicate our families and are concerning when we think about the kind of education that we'd like our kids to be receiving. That said, on the good side, you can see here on this map in dark green, there are 7 states that have laws that require the inclusion of LGBTQ people and history in school curriculum, including California and Illinois. So I went a little long, but I'm happy to talk about other areas of life where queer and trans women and families are facing challenges, or research about queer and trans women. But I think we're ready to move to questions, both from Mimi and from all of you attending.
Thank you for, that was just a wealth of knowledge, and I am really happy that we recorded it, because that's a lot of really important information. So now this is going to bring us to the unrecorded portion of our workshop, because this is going to be the Q&A section with audience members. So I am just going to wait for end that recording. So before we started the panel, everyone, we were talking about the confirmation hearings, and one thing that I found interesting during the confirmation hearing was a gentleman from the South, and I really can't remember which state he's from. But at any rate, he asked Ketanji Brown about the Dred Scott case, right? Dred Scott versus Sanford, and he brought up that case to talk about how it was repealed later. And I know that we have a lot of protections in place now through the Supreme Court. What would happen if those protections are then later repealed? And what could that mean for queer and trans mothers? For instance, with marriage equality, as he was inferring, if that was repealed, what could that mean for our parents today? And that question is to anyone on the panel.
Well, I'd love to just talk a little bit about this, and I'm happy to have anybody else jump in, of course. I think obviously that's a very scary prospect, and certainly something that people have been talking about. We think it's unlikely that Obergefell in all cases will just be completely undone and replaced with a different constitutional principle. But I think it is, obviously scary for people. Lots of people are worried about it. We certainly are seeing a lot of attacks on our families, children, and especially on transgender youth. There's such a focus on families and education and parental decision-making right now in the discourse. And so it's a very scary prospect for people to think about. In terms of family law, there aren't actually a lot of Supreme Court decisions that really impact how family law works, because family law in many ways has always been the place of states to regulate and determine. So of course we have constitutional individual rights of equal protection and our what's called due process rights that touch on things like being able to make decisions to form a family and to marry, and that those are our fundamental rights that are established or explained through Supreme Court decisions. And that can have an impact on how family law works. But at its core, how family law works for most people and in every state really is just how states have designed it. It certainly would be devastating to have, Obergefell overturned, but there are lots of protections for people that aren't tied to marriage. And I think it is part of a reason why it doesn't make sense to have all parentage protections being tied to marriage, because lots of people aren't married and they still have children and they still deserve to be recognized in the same ways. There are states that still provide a lot more recognition to married parents than to unmarried parents. But we have really actually old constitutional law from the Supreme Court from decades ago saying that that's actually unconstitutional too, that we can't treat children who are born to or conceived by unmarried parents as not having rights. And so I think there are a lot of ways that families could still have protections, even if something so unthinkable would happen.
Can I just add to that? And I'm not a lawyer, Cathy, you are, so correct me if I'm wrong, but I think it's important to realize that simply being on your child's birth certificate is not really enough. My understanding is that that's because the birth certificate records parentage, but it doesn't actually establish it. And also a parent's right to be on the birth certificate, particularly a non-biological parent's right to be there, is often because of their marriage to the biological parent. So if you're worried about that marriage not being recognized somewhere, you need some other parental recognition other than simply being on the birth certificate, like a confirmatory adoption or a court order of parentage.
Yes, absolutely. It's really important. I think people don't always recognize that birth certificates alone don't completely protect people. They're evidence that you're a parent and you move through the world with them. They certainly allow you to go to school or to the doctor or travel and show that you're a parent. And it's very important for people to move through their everyday life. But if you're actually in court on a case, alone being on the birth certificate isn't necessarily going to mean that you're going to be recognized as a parent. So like Dana said, a court order or an adoption, or if you can, a voluntary acknowledgement of parentage, also all provide that protection that goes beyond a birth certificate.
I just wanted to add that, I think definitely this court is scary in terms of their willingness to take cases. And I think for me, I think more about the Dobbs case and the impact on queer families as the immediate threat. We know that our families and queer people need to access reproductive health care, and the decision that this court is going to make in June really does threaten our ability to decide when and how to have families before we even get to other decisions that they may look at. I also think we need to look at the extent to which this court in particular is interested in expanding religious exemptions, which is essentially the ability of someone to say, I don't agree with you, I'm not going to follow the law. I think that is a far bigger threat to our families and to the recognition that our families have, and the ability to have your marriage license recognized at the hospital and have it recognized at the other places that you need to access benefits. To me, that is a far bigger immediate threat. We have cases that are moving through the courts on this very issue. And so I think we can worry about Obergefell, but I think that feels much farther out to me if it is even a possibility. And I think there are lots of ways to distinguish the cases, and I would leave that to Cathy as the attorney. But I just want to flag that I think there are many reasons to be concerned about this court and our families, but not around the actual ability to marry right now.
With that, I want to actually bring up a audience question. I think it flows well. The question is, well, then if marriage equality, well, not marriage equality, but to your point, Naomi, if marriage equality isn't too something that we should really worry about, audience question is, then what should we be looking at? Are there, other than Equality Act, or are there other federal laws or legislation we should be keeping an eye on to improve the climate for queer and trans mothers? And again, that's to anyone.
I mean, I will start with the Equality Act because I think we have a very unique moment right now. We need to get to 60 votes to pass the Equality Act through the Senate. It's already been passed through the House. And the Equality Act does 3 really awesome things that I think speak to the intersectional lives that we live as queer, trans parents. You know, one, as I mentioned earlier, it explicitly adds sex orientation and gender identity protections to federal law in 8 or so key areas, from employment, to education, to healthcare, to jury service, to federally funded programs. It also adds sex protections in 2 areas that we don't have currently. One that I mentioned earlier, which is public accommodations, and a federally funded programs. And I think not very many people realize that women don't have those protections right now under federal law. No one does for sex discrimination. And finally, for all protected classes, including those who are already in the law, race, color, national origin, ethnicity, it would expand places of public accommodations to be more in line with where we go today. So currently, federal law doesn't prohibit discrimination in taxi cabs. It doesn't prohibit discrimination in clothing stores. State laws do that, but federal law doesn't. And so really, I think of the Equality Act as kind of a modern civil rights bill, because it does have these incredible expansions around race and ethnicity, around sex and gender, around sex orientation and gender identity. And so many of us sit at the intersections of many of those different pieces. And so I think it's a really important thing to keep an eye out for. I think I'll let Cathy and Dana talk about, I think, what are the really incredible things that are happening around parenting law changes that to me speak to just the innovative ways that queer people have always had families, but are now finally being recognized in the law.
I'll pick up on that a little bit. I live in Massachusetts, and Massachusetts was the first state to enact marriage equality in the US. But it is now the only state in New England that has not passed comprehensive parentage reform laws. There's actually a bill currently in the legislature that would do that, and hopefully it will pass this spring, but we are still not there. Having said that, Connecticut passed a terrific Parentage Act last June, which does some of the things we've already talked about in terms of gender neutral language, in terms of extending voluntary acknowledgements of parentage to same-sex couples, and a lot more. So I would say, be aware if something like that is moving through your state. And I think Cathy can also talk to a few others that are trying to do similar things. I also know that Colorado, for example, has a bill that just moved ahead in the Senate, in the state Senate yesterday, to streamline the confirmatory adoption process. So instead of having to go through a home study and fingerprinting and a background check and all of this rigmarole to adopt your own child, if it's a confirmatory or second parent adoption, they're going to make it a much easier process. Small filing fee, fill out a few papers and you're done. So if you know of things like that in your state, or if you follow NCLR or MAP to find out where things like this are happening, to be able to support it in your state is really a great help.
Thank you. Oh, and thank you for sharing the legal hotline, helpline. And
I'll also just add,
we'll also share that to everyone who had registered, and we'll have that up on our site too. Sorry.
I'll also add, and I don't know if Cathy knows more, I think we need to also keep an eye on efforts to limit reproductive rights, because a lot of those impact many of us who are trying to have kids using assisted reproduction. Bills that that look at when personhood begins have an impact on those of us who are are starting our families through assisted reproduction. I'm not an expert in that area, but I do know that there's certainly been some talk that those could be damaging to our abilities to form our families in that way as well.
Absolutely. I think, as we make progress, of course, there are bills out there that can limit our families' rights, and certainly many of the ways that, as Naomi was mentioning too, that there's attempts to restrict reproductive freedom and reproductive health services. It also impacts our families in a lot of different ways, and that's really important to keep an eye on. I did see a question in the chat about known donors and the recognition of families who use known donors in particular. And that is a way that states have a lot of variation in how they recognize families that might have been formed using a known sperm donor or a known egg donor. And part of the issue is that a lot of states really just don't have any assisted reproduction laws at all. And the only way people can have a measure of protection is by using an unknown donor. And that's kind of how people are able to create a family without having the genetic provider of sperm be recognized as a parent. And so those states people do really struggle with the ability to use a known donor, which is such a wonderful choice for so many families to have someone or who is known or related to the non-genetic parent. And so many families are formed that way. It's also, of course, much more financially affordable for people. So it's definitely something that we focus on and work on a lot. The bills that Dana is talking about that are comprehensive have changes that will address and allow people who use known donors to be recognized as families. And that's certainly one of the big issues that we work toward in bills across the country. And we do work in any state where we can that is potentially open to considering these issues and recognizing people and recognizing the different ways that people form families. Yes, and yes, we did a lot of work on the bill in New York that included surrogacy and assisted reproduction, and to make sure that especially the assisted reproduction provisions were broad enough to include people who used at-home insemination with known donors, for example. That's something we see a lot of states excluding from protections, which of course has a much greater impact on low-income families who are much more likely, of course, to use at-home insemination with known donors. I think that's another reason why the voluntary acknowledgement of parentage process, which is also becoming a little more popular among states and more states are doing it, is so important. Because if it allows you to be recognized as a parent when you've used a known donor through at-home insemination, and everyone can just sign a free form with a person who helps you fill it out when your child is born at the hospital, it is a way that so many more people can have access to that level of protection that otherwise you would have to go and get an adoption to obtain. Great. Well, I'm so glad to hear that.
I wanted to talk about some of the advancements that we've had. So I know some of the wins that Lisa brought up, for instance, is the move to have birth certificates name parents as parents and not mother and father. And we do talk about intersectionality, and for a lot of Black mothers or Black women have been excluded from being able to call themselves mother. And so now would like, and so being called mother, I think, is something that's actually cherished and wanted for some groups of folks, especially if that's been denied. So the question is really, how has the legal definition of motherhood changed in recent decades? Have there been any inroads made to detach the legal definition of mother from cisgendered identities and genders assigned at birth? That question is to the panel. Anyone? Don't all jump at once.
I want to dominate, so I would love to hear from anyone else. But yeah, I think what Dana was saying about so many states considering gender neutral parentage laws is really important to this question, that recognizing that people of all genders can have every possible role in the process of conceiving or adopting children, that you can be a person of any gender and give birth. You can be a person of any gender and provide an egg or a sperm that helps conceive a child. And the ways that the law is moving toward using more inclusive language and recognizing that people play certain roles in the conception of a child, and that those roles are not, can't be described through proxy by your gender. So we see a lot of statutes that just say, oh, mothers need to have this during pregnancy. And so rather than recognizing that there's other ways to be a mother, there are other people besides mothers who are pregnant. And so I think that's a really important step forward in the law.
Yeah, I'll just add a personal comment, which is that when my spouse and I were having our kid almost 19 years ago now, we petitioned for a pre-birth parentage order. We used reciprocal IVF, so it was my egg and my spouse carried. And we decided it would be ridiculous for me to have to adopt my own genetic child. So we worked with a lawyer, petitioned the state of New Jersey, and got a pre-birth order naming me parent, which was great. But I distinctly remember that the judge said I couldn't be named as a mother. It had to be as a parent, because there couldn't be two legal mothers. Now, I don't know if that's changed in the the time since we did that, but I thought that was interesting, especially given how much we have to fight otherwise to take off mother father from forms and put in parent and parent.
I just wanted to sort of take us in a different direction, which is related less to parenting, but also to relationship recognition. And we've seen a couple of states recently update their statutes, their marriage statutes, to be gender neutral. New Jersey is the most recent one to do that. But I also think we have seen a few different cities look to recognize families that may have more than two people. So the city of Somerville and Cambridge have recently been working to recognize families that have more than two adult partners. And I think that that's a really exciting way. And when we think about what that does that mean also for children in those families, and the ability of the adults to be connected to one another, and then potentially children to be connected to more than two people. And again, just I'm so excited about the ways that our laws are finally keeping up with what have been family configurations that have been in existence for a very long time. And so I think it's an exciting time to be thinking about how to shift what legal structures exist.
When we started the panel, Lisa, you mentioned that you now have a daughter who is currently, I think, going through the process of family formation with her partner, and how her process is just dramatically different than what your process was like.
Correct.
Right. But there's still issues of litigation that still come up today between queer parents, especially during times of divorce or something. What advice would you give to those parents, knowing that things have changed, right? But who are having to go through litigation? Like, what would be your sage advice given your own experience?
I would say do research, find out do your research, because you don't want to be caught in a situation like I was in. You don't go into hopefully you can trust the other person, but you always have that in the back of your mind, what if is going on. So find out what the rights are as far as, buying a car together, or who owns what. It was a nightmare, and it struck me from out of the blue when my daughter was pulled from me, and I had gone through all the steps I thought were the right one. And I'm a retired scientist, so I do research, and I researched into the pre-birth declaration, which was very new in California in the year 2000. So they hadn't been challenged yet, and mine was the first one to be challenged. So at that point, they no longer can, now it's a valid document and you don't have to worry about things. But and don't shortcut things. If you are thinking about saving a little bit of money, it can cost you a lot of money in the end if you're wrong. Trust me, I've paid for a long time. So don't shortcut things, put the money into it, get the legal advice, better on the front side than the back side. And it's very interesting watching them plan their wedding. And they live in the Bay Area of California, where it's, you know, very open up there. And it's just wonderful seeing them worry about things like, you know, the flowers at the wedding rather than who's going to, you know, have a valid marriage or not a valid marriage. So it's pretty exciting what I have seen. And recently my wife and I took a trip across the country. We went from Oregon to Maine and then drove all the way, all the states. And it's tangible. You can feel where you are, that sometimes you're hated. And that was really eye-opening for me. And we knew at certain times, you know, stand apart, don't hold my hand, because it was a dangerous situation. But I've seen some progress in the Western states.
You know, Lisa, you bring up an interesting point. I just even a person that I know, she was the non-biological parent, and actually the non-biological mom, that's how she identifies. And when she and her wife went through a divorce, her wife took the child to a state that didn't recognize, he didn't have the same legal protections for queer and trans mothers. What advice do you, or what legal protections are there for parents in place today? Or is that even a possibility for a parent taking a child to a different state with less protections? And I guess that could be Lisa or anyone really.
I've seen NCLR work on cases that went to different countries. I've seen them where they've gone across to state line and you're in a state that is the other side and not going to agree with how we're living, and they don't enforce those parental rights. And I've seen that happen way too many times. I'm on different websites and blogs and Facebook, and I follow queer parenting and some of the struggles that some of the people are having, and I can feel it in my bones when I see this, and I go, yeah, I know how you feel. And but yeah, protection is not everywhere for us.
Yeah, you know, if you look.
Dana, why don't you go, and then Cathy, if you want to follow up after.
We're all being so polite. Yeah, I was just going to say, you know, there have been any number of really horrible custody cases like this over the years. I think things have gotten a little bit better, but again, that's why it's really so important to get all the legal protections you can with confirmatory adoption or voluntary acknowledgement of parentage or a pre-birth court order, because those are absolutely ironclad and enforceable across all states. And parenthood changes relationships. You go into it thinking everything's wonderful, and you just don't know how things are going to happen or how things are going to transpire. I mean, all the best to any couple. My spouse and I are going to be celebrating our 29th year together in just about a week, but sometimes you don't know. And so it really is better to be prepared.
And I was just going to add the practical advice that if that is something that you're facing and you're, starting to you're having a breakup or a custody dispute, and you believe your child is or about to be taken to a different state or a different country, that it is important to try to get legal advice and go to court as soon as possible, because there are timing issues with whether or not you're going to be able to have your case in the state that you're already in, that may have more friendly laws. And how this works internationally is completely different, of course, as well. But it's one of those things that actually has a timing attached to it. And so it is something, it's important to talk to an attorney as soon as you can if you believe you're facing that situation.
I just wanted to throw in some demographic information because I'm a stats nerd, but Lisa's comment about driving across the country, like when you actually look at states where queer women are raising kids at the highest percentage. It might surprise folks, but the highest percentage state is actually Mississippi, where 49% of LGBTQ women are raising kids, right? So we may think about sort of where families live, but we actually live everywhere, and we live in communities that look like who we are. And so just to recognize that what that means is that there are states where there are incredible hurdles to get over in terms of a state like Mississippi, when you look at the laws around employment discrimination and schooling and all of these different pieces that queer families experience, but yet, you know, there's a high number of queer women in Mississippi raising children, and those families need to be protected just the same as families living in Massachusetts or in California.
Naomi, thank you so much for bringing that up. You know, everyone thinks it's San Francisco and the Bay. It's not. Actually, the majority of LGBTQ headed households live in small town America and live in states that actually don't have the most protections, right? And so it's really, thank you for praising that. Dana.
Yeah, now I'll just tag on to that, I think the image of queer parents that we often see on television is, two upper middle class white couples, white parents. And to see if I get the stat right, I think parents of LGBTQ parents, people of color, are twice as likely as LGBTQ white people to be parents. So that has all kinds of implications for who our community is and what other things they're dealing with, legally and in our society. So that's really important to remember. We're not just the upper middle class, white couple.
Yeah, to throw in one more sort of stat that I think really helps demonstrate the extent to which even our conversations about who families are, more than half of queer women are bi. So just think about that and think about, we know that many of them are partnered with or appear to be partnered with men. And so just when we think about what queer families are, yes, it's often intentional, planned families with two women, but it can come in all kinds of configurations. And given that more than half of queer women identify as bi, I think we really do need to think about the diversity of what that means, and the ways in which we develop services to serve queer women in all of those different kinds of relationships and family configurations, and not necessarily just what it looks like from the outside.
I do want to ask, thank you. Everyone is saying like wonderful, powerful, important gems. So thank you, everyone. Again, I can't thank you enough. There are more legal loopholes that we have to jump through, right? To have protections. Even an audience member brought up using a known donor. I remember in going through like our options, like I just remember so many more legal fees or medical fees that were attached to the type of donor we decided to go with. What kind of, are there lawsuits that families, queer mothers and trans mothers can file to get back some of their damages that they face in all of these different extraordinary legal fees to just be recognized as a family or as a parent and a mother?
So I can speak just for a minute a bit less about the legal fees, but more about sort of the coverage of insurance around efforts to conceive and have a child. And so there have been both legislative efforts in some states to make sure that insurance companies are covering the costs associated, say, with sperm and insemination costs, and to not require that you prove infertility for some number of months, which how do you do that when you are in a partnership with someone who has sperm, is a question mark. So I think that's been one sort of piece of legislative advocacy, but then also there has been litigation in a few states to sort of say that the requirements put on some queer families to meet those standards under insurance are unreasonable and discriminatory. So I just want to flag that's less your question, maybe, and I'm sure that Cathy can probably speak to the other pieces, or Dana can, but I just wanted to flag that because I think it is an opportunity for advocacy and another place to think about what does your insurance cover, and what does the state law in your state require that they cover, and making sure that you're getting what should be covered, and knowing that there are those added costs in many instances for us to create families.
Yeah, I'll just jump in and say, as with benefits to same-sex partners, I think corporate America is often ahead of legislation in this regard. There's, I think, more and more companies now, particularly larger companies, that are offering expanded fertility benefits that don't require that proof of infertility, for example. Now, of course, there's a socioeconomic impact there because it's only the people who have jobs at those companies who have access to that, and that's why we also need the legislation. But I think more and more companies are trying to fill in some of the gaps.
Lisa, if you could just speak to what were, I'm talking about recovering additional fees and costs because that's where we are today, right? But what were the fees and costs that you were going through, and what did you have to fund in order to have your family?
Well, I like I said, I was a scientist. I worked at a hospital and was a lab director. So I took on 3 jobs at the time. I worked daytime, PMs, and weekends to pay my legal fees. And they were up into $250,000. So by the time we went through the Superior Court and got a challenge, and then went to the appellate level, and then the Supreme Court, it drug out for about 3 years, 2 to 3 years. So it became very, very expensive. My credit cards, thank God for American Express. So I did, and what's interesting is when I was at the appeals court, there was a comment made by one of the judges, if you would have been married, it was in the writing. And I thought, well, I can't get married because your laws don't allow me to get married. So I should be suing you because you caused all this problem. But of course, I didn't, and that wouldn't have gotten anywhere anyway. But this was back in 2003. There was no marriage there. So I basically had to spend my retirement and run up my credit cards and work my rear off for a couple of years. So it got very, it was very struggling. So I don't wish it on anybody. The good thing was my daughter was too young to know what was going on. She was 3 and it wasn't talked about. She just knew we were going through a divorce. She didn't know all the cases that were going on and how this impacted her. But the strange thing was after I won the case, the biological mom basically gave in, and I got to have my shared custody, and it was just the strangest thing. So my daughter didn't really realize what was going on at the time. At least I didn't let her know about what was going on, and she seemed to be pretty naive about it.
Did she give in, or did you just win the case?
Yeah, I think she realized at the point that I could maybe turn around and grab full custody, because she did all the tricks. She did the "you molested her," so my daughter had to go to a forensic exam, and she did all the tricks to get her out of my custody. So it got nasty real bad.
My God, I'm sorry for that, and really I thank you for what you went through. I'm going to bring up travel. I think Cathy, you talked about protections when folks are traveling abroad. But what about for the cases? There was a law that passed through the international courts where when you're traveling now, you have to have, with a child, you have to have a birth certificate present. And there are some states that allow you to have mother and mother or father and father, just pick the term that you find most affirming on that birth certificate. And when you enter a country or traveling through countries where same-sex relationships are illegal or queer identities are illegal, what kind of protections can be in place for those parents, if anything?
I mean, I think that is still a danger for people. It's not necessarily a way, from the US to protect people who are traveling in countries where laws won't recognize them or who, criminalize their identities. And obviously that's still a danger when people travel. In terms of traveling with your children, you need to be able to prove that you're a parent, and you need to have proof and travel with proof of that you're a parent of your children. And having it's much easier for people to get birth certificates now. We do because of marriage, but also because of adoptions and voluntary acknowledgements. There's a lot of different ways that people can get birth certificates, at least accurately list parents. But there can still be challenges because not every state is going to list your gender correctly on the birth certificate. There still are many states and many people who are listed as mother and father, and that's not their gender. They don't have an option to change that. And this is also particularly a problem for transgender people who are parents, particularly if they transitioned or legally changed their name after their child was born. Most states don't allow you to change your gender or your name on your child's birth certificate. And so you would then be traveling as a transgender parent with a birth certificate that has the legal name you had when your child was born, and you may have the gender you were assigned at birth on, even though you now have identity documentation that shows your legal gender and your legal name as being different. So for one, of course, that can out you, and also is just not reflective of your family, but also it can be it can be very difficult to show that you are that person. So then you may also need to travel with proof that you changed your gender and name to show that you are the person who is listed on your child's birth certificate. We were able to get to change the law in California recently to allow people to amend their name on their children's birth certificates in these situations, where people have transitioned and or changed their name. But that's still, unfortunately, the reality for most people is that they can't change their gender and name on their child's birth certificate.
You've answered all of our questions, really, but I just want to just to the last point that you were making, Cathy. What changes have taken place in trans mothers recognition and protections?
And I'm so sorry, but you cut out for me. Could you repeat the question, please?
Yeah, sure. What changes have taken place right now in regards to trans mothers and their protections?
Yeah, so as I mentioned, there's still a long way to go for transgender parents in having the same kind of protections that LGBT parents have from discrimination and recognition. A lot of the laws should operate the same way for transgender parents, but of course, as a reality, that's not how it happens. We have a lot of laws that remain gendered, that expect that people who give birth are women, that will only list you as a mother if you gave birth, and that's how you are a parent to your child. And so there's still a need to make those changes. But there are a lot of states that have made those changes, as well as states that are starting to look at how people are listed on a birth certificate, being able to choose if you want to be listed as mother, father, or parent on your child's birth certificate, rather than having only one way that can happen. And also, marriage equality did help transgender people too, because before marriage equality, we had lots and lots of cases arguing about whether transgender people were validly married to their spouses. When we had gender restrictions in marriage, you had to prove that you were a different sex couple to have a valid marriage. And so we had cases arguing about somebody's legal gender at the time they got married and whether they were really a man or really a woman, which is a horrible thing to go through. And a nice consequence of marriage equality is not just for same-sex couples, but also for transgender people in marriages, that they don't have to prove what their legal gender was at any particular time to have a valid marriage. When we take away the gendered restrictions and the gendered language from law, it also opens it up to being accessible and open and protecting people of every gender. And the same is true, of course, for non-binary parents and non-binary people in relationships as well.
I just wanted to share, one added piece. I think Cathy mentioned the birth certificate piece and having the mismatch between your current name on maybe an ID and a birth certificate for your child. But we still have states where trans people can't update their driver's licenses at all. And so, what does it mean to be the parent who's asked to show an ID to pick your child up from school, or to pick your child up from daycare, or to register your child at the hospital when you have to show ID and your name may not match? And so I just wanted to flag that that's sort of a meta issue that's separate from specifically related to parenting, but I think that it definitely is a challenge that we know trans people are experiencing and non-binary people are experiencing just in daily life. And definitely as a parent, there are more of those instances and the stakes are high, when it does involve your child.
Yeah, I think we, thank you. And I think we're going to be wrapping up shortly. I forgot that half of our panel is on the East Coast and it is super late. And I also, there was something that Naomi had texted in the chat, and I just want to make sure that it's accessible to everyone in case they didn't read it. Naomi had mentioned that she wasn't legally married, and therefore her second parent adoption costs were eligible for federal adoption tax credit. So
my understanding that's still true. So if you're not adopting, essentially it's not considered a step parent child adoption, where you're essentially married to the child's other parent, that it does qualify for federal tax benefits around adoption costs. And so obviously that's a decision that you should talk to your accountant with, but because we couldn't be legally married at the time when my son was born, we did the second parent adoption in our state, we were able to file that tax credit, which certainly minimized some of the costs maybe you were talking about that our families do bear. Although I think there's now so many more low, no cost options that Cathy mentioned, hopefully folks can take advantage of those rather than spending the thousands of dollars that we spent, to have those bootstraps and suspenders and all of the things, given that territory was so much less certain than it is now.
And same here, I was able to take the tax credit for some of the legal costs that I had put out. Wasn't quite enough, but I was still able to take that on the taxes.
not to mention the emotional toll. And I think that's also not one thing that we don't always think about when we're talking about legal cases or protections. There's a huge emotional toll that we also, I guess, have to be cognizant of and find ways to support our community when we're going through these things. If I want to, before ending the workshop panel, I want to really bring it back to the panelists. Are there any final words that you'd like to share? Any thoughts?
I think the last thing I'll say is just how excited I am about the changes that are happening, you know, the changes that Cathy and Dana mentioned, and that I also think we are paving the way for positive changes for all families. That when I think about the innovations that we're asking the law to make, it actually supports kids in all kinds of families. And so yet again, I think we are trailblazers and we're helping to shift the narrative around what families look like and the legal recognition that they need. And I feel like that's really exciting to continue to feel that inspiration from our own community.
I agree that it's phenomenal what's going on. It really opens my heart up.
I'll concur and also say, I think the supports around parenting have also grown tremendously. If you look at the way we're connecting with other parents online, and there are support groups from our family and elsewhere that are so much more widely available, and books, both for ourselves as queer parents and for our kids that have representation that just didn't exist even 10 or 20 years ago. That gives me hope as much as the legislative moves as well. And I am an optimist. I do believe that things are getting better. We are experiencing some setbacks now, but I'd like to think we have a positive outlook ahead.
I do too, actually.
And the only thing I just want to add is I think when we approach how do we change the law and how do we change how families get recognized from the perspective of making sure that we are including the families who are least protected already, families of color and low-income families and transgender parents, that we end up creating systems that really do benefit everyone. Having gender-neutral parentage laws don't just benefit trans and non-binary people, they benefit everyone by being clear that you can play any role and be any gender in creating a family. And when we look at how low-income people are more likely to use at-home insemination, when we make assisted reproduction laws broad enough to encompass all of the types of assisted reproduction, we also protect a lot of other people as well. And so I think having that focus and that frame and how we change the law is really important.
Well, thank you, everyone. Thank you so much. We don't have any more audience questions. Thank you so much for your time and your wisdom and your experiences and your struggles and everything that you put into this work. So thank you all for joining me tonight and sharing this with our community. I really appreciate it.